Welcome back. Yes, Mr. Ubani, former chairman of NBA Spidel, joins us next to help us make sense of some of what we hear and read from the courts and see what this means, such that we can internalize and get the right meanings to relate to them properly. So it turns out that it's a case concerning elections. Good morning, Mr. Ubani. Thank you for joining us on the program today.
Thank you. Good morning to you, my brother.
Yeah, so let me just go over this again. I mean, many might have seen it yesterday, but Justice Donatus Okorowo of the Federal High Court, Abuja, did order the Attorney General of the Federation and the Independent National Electoral Commission, INEC, to halt the prosecution of the suspended Adamawa Resident Electoral Commissioner, Hudu Yunusa Ari, for declaring Senator Aishatu Dahiru Benani as winner of the Adamawa governorship election on the 15th of April. Now, he gave this order following an ex parte application brought by the council to Aisha Benani, Mike Ondoaka. Now, the court held that since the matter is before a tribunal and the parties have submitted to the law, the parties should maintain a status quo on the matter pending the conclusion of the suit. Now, at the mention of that suit, counsel to the applicant brought before the court two applications, a motion seeking to interpret Section 144 of the Electoral Act 2022 and an order seeking to maintain status quo in the matter pending the determination of the suit. So they also went ahead and cited Section 149 of the Electoral Act 2022 on the same subject matter. If I could just go ahead and read that to you so you could help us break it down. It says, notwithstanding any other provisions of this act, any defect or error arising from any actions taken by an official of the Commission in relation to any notice, form, or document made or given or other things done by the official in pursuance of the provisions of the Constitution or of this act, or any rules made thereunder remain valid unless otherwise challenged and declared invalid by a competent court of law or tribunal. Mr. Ubani, what does this mean?
Yes, let's try to piece this together. Remember that sometime in April, there was election in Adama, I think supplementary election, in which Hudu took over the proceedings. And then while the collection was still ongoing, he declared the APC gubernatorial candidate as the winner. And that was surprising to many persons, including INEC, that is his employer. So what they did was to actually suspend him and then called in the police to investigate what they considered an infraction against the electoral law, and then also send his suspension to the president for approval, which the president gladly approved. And so the investigation continued, and then the election itself was completed, and INEC announced a winner, and that is the governor now in Adamawa. And so while this was going on, the issue of investigation was an issue. At the time he went to court, he wanted the police to stop the investigation. I think that did not hold sway. So eventually, recently we were told that that investigation has been completed and the 6-count charge has been filed in Adamawa State High Court. That is what is going on now. Before yesterday, we heard about the expiatory order that was granted to maintain the status quo. And, so everyone became very surprised. Members of the public, again, were thrown into confusion. What is going on? Can a court actually stop the trial of a criminal? A criminal case, that the police itself has completed, and the INEC is the one heading that trial. So that is what we're here to analyze and look at whether it was right for any trial to be halted, pending the determination of the substantive suit that are before the tribunal. Are they the same? This is a criminal case, and the other one is a civil matter. What is actually before the tribunal was the issue of his announcing the result while the collation was going on, part of the grounds of petition before the election tribunal. So what has this criminal trial got to do with the substantive suit that is presently pending before the election tribunal? But the good news is that the court adjourned this case to 18th July, asking the respondents to come before the court and tell the court why the relief that have been sought by Madam Binani will not be upheld. And so the INEC has opportunity now to respond to this ex parte order that has been granted, maybe asking that it be set aside because an institution that is empowered by law to carry out investigation has completed, and the next thing is to have the accused person charged to court, and court cannot stop the trial of a criminal process, that is done in accordance with the law. That is what I expect to happen on 18th. But whatever it is, we are totally confused. This penchant to rush to court, whenever investigation is being called upon by any security agencies, these political people rush to court and ask the court to stop the investigation. Now we are beyond the issue of investigation. We are going now to trial. And then the court is also halting the trial of a criminal case. So it's becoming very confusing to the members of the public. What is actually going on? Are we using the judicial powers effectively and in accordance with the law? Are we abusing it and all that? So these are some of the things that will crop up in the days ahead.
Well, in terms of administration of justice and the perception of the judiciary in this kind of matters, because even today, I think, who was it that was suggesting that sitting judges should not be sitting over election petition tribunals because they just want to ensure that the judiciary is really and truly the real meaning of the word independent of whatever else goes on, court of public opinion or wherever, just face the law, plain and simple. So we thought that these kind of matters have been discussed and addressed by the CJNs before now and now, such that judges conduct themselves in ways that are very clear, in clear terms, and not unambiguous, such that it gives a wrong meaning to the members of the public who may begin to raise questions. But this particular one now, does it appear as though all of those calls may have been falling on deaf ears?
Yeah, we just finished a conference. I'm talking about SPIDL recently in Lagos, and part of the discussion is this issue of judicial intervention in electoral matters. And the conclusion, by all speakers, that were invited is that, look, we're really overburdening the judiciary with this issue of electoral matters. If you go to courts, almost all the courts in the country today, all the criminal cases and the civil cases are on permanent adjournment, pending the time that these judges will come back from the election tribunal petition, where most of them have been assigned to go and do that responsibility. And all those cases are halted. The criminal cases are not going on, the civil cases are not going, even those on fundamental human rights, ordinarily that should receive priority, at least, it's not being given that due attention. People are languishing in jail because of the issue of election petition that is presently going on. And the issue is, why are we really, suffering, litigant? Why are we suffering the judiciary? Why are we even overburdening the judges with electoral matters? Is there no way we can even ensure that our electoral process, come to the level of fairness, that people do not in any way go to court, to challenge most of these elections, the election outcome. So it is an issue. Then the issue of ex parte, we have also it's been discussed within the SPIDL cycle, and retired justices and serving justices and even learned seniors, lawyers, were invited to talk about this issue of abuse of ex parte. That it's only on very rare occasion, a very rare issue that has to do with maybe dissemination of that subject matter or destruction of that subject matter that will actually make the court to interfere with this ex parte order. Because the most important thing is that the other party should be put on notice. If you have come to say, INEC should not in any way prosecute, why is INEC not put on notice in this matter? Why must it be granted ex parte? But as I said earlier, the matter is adjourned to 18, and INEC will have the opportunity to tell the court why that ex parte order should actually be set aside. So the issue of abuse of ex parte is an issue in administration of justice. The issue also of burdening the judiciary with all electoral matters. All electoral matters, while other cases now are pending before the various courts in the country, is something we have to look at. Why are we doing this to ourselves? Why is the judiciary being used only to serve the interests of politicians, whereas ordinary citizens whose cases are pending before the court are now suffering? But the judiciary is not being used to ensure that the political class, is being serviced, to the detriment of the majority of Nigerians. So these are issues we really have to keep on, raising, within important channels like yours, so that let Nigerians begin to decide whether we're doing, right to the country or we're doing the wrong thing to the country. So it's part of the discussion in administration of justice. Thank you, my brother.
There's so many questions, swirling through my head. But I mean, especially as you talk about this issue of electoral cases seeming to supersede almost every other case that is in court. As some people would say, but we've been down this route before. We've been in a situation whereby electoral matters used to take 3 years, thereabout for them to be resolved. And that did not augur well for the people whose tenures were time-bound. And, sometimes somebody who was not supposed to be there would have spent almost all of the time that the rightful person should be there. We're still reaping the consequences till today. So the question will be, what will be the halfway ground, in making sure that other cases do not suffer at the same time, these matters which are always time-bound should be heard, expeditiously. But let me ask you about this particular matter. And I know that you won't want to delve into the merit or demerit of the case now, but looking at it, they have also said that, look, if the judge should find that the application that they have made is frivolous, at the end of the day, they're willing to pay whatever it is that the courts deem fit. That's part of what it is that we're seeing here. But I'm wondering, this matter which they have brought before the court, seeking an expertise for, is supposed to be something that has an effect on the election petition matter, which Ms. Binani has taken before the election petition court, which is where her matter, should have been determined. Don't forget that she had initially brought her matter before the Federal High Court here in Abuja, and the judge had asked her or her lawyers, to explain to him if he had jurisdiction over the matter, and I think it was determined that he didn't, and whatever it was that she was seeking should, rightfully go to an election petition court. Do you really see the two really being intertwined, that if INEC was taking action against Mr. Ari, then, it was going to affect whatever case that Ms. Binani was presenting in court?
I don't think the two cases are related. I don't think the two cases are actually related. The grounds for petition before the election tribunal are specified by the Electoral Act. You go to court on ground whether the candidate is qualified. And second issue is whether there is the election process itself is very corrupt. There are some malfeasance or malpractice committed in the electoral process. And finally, if the candidate did not in any way garner the valid vote, that should entitle him to be declared the winner. These are the three grounds under which you go to election tribunal. Now, what Hudu is facing is the issue of electoral malfeasance, electoral offense. They are saying, look, were you actually the returning officer? He was a reg, quite all right, of Adamawa. But was he the one that was appointed as the returning officer for that election that took place? Was he the returning officer? I don't think he was. Going by facts, that was revealed, he was not the returning officer. Then secondly, why the collation was going on? Why the collation of that result, that particular election was going on? This man went ahead before the entire members of the public to announce the result when the process has not been completed. And that was why INEC, the employer, had to intervene and say, look, this is absolutely wrong. Yeah, we have a right to review these things, when you do it, but we have not done it right. And for not doing that right, we are suspending you. We are not only suspending you, we are also handing you over to the security agencies to ensure that they commence investigation as to your culpability. Now, the police have actually completed that investigation and found out that he was culpable, that he committed an electoral malfeasance, and for which he should be tried. And so what is going on in the election tribunal is purely on an issue of challenging the outcome. It has nothing to do with crime that allegedly has been committed, for which I don't think that the court has any right to stop an agency from prosecuting an offender. So that is to me, two issues, that are clearly at variance, that shouldn't in any way be, modeled up, But this man is modeling, the lawyer is modeling, saying, oh, we cannot in any way try this man until the final outcome of the election petition tribunal. Whereas, from my own analysis, from my own understanding, these are two separate cases. That one is criminal, this one is civil. And if somebody has been found culpable and all that, so will any court stop trial of a suspected criminal? Can a court, in the real sense of it, stop somebody from being prosecuted? I don't think so. And I don't think that our court should now probably descend to this level of doing some of the things they do. But as I said earlier, he has adjourned the matter to 18. Let's also see whether, one, do the court even have jurisdiction in this? That has not been challenged. These are some of the issues that will come up. Does the court at this point have even jurisdiction of the matter that is pending before the election tribunal? When election itself has been announced, the result has been announced and all that. So these are some of the issues that will crop up, on 18 when this matter comes up, because I think that INEC would not be sleeping. The Attorney General that also has been joined as a party also, the office of the PAMSEC will not be sleeping. They have to file certain things in order to actually bring to the notice of the court that this is clearly something that is outside the jurisdiction of the court. So I think something will come up on the 18th concerning this matter.
In the meantime, is INEC bound to obey this particular court order? Do they have to stop the prosecution whilst they wait till the 18th of July?
When you say maintain status quo, sometimes it gives lawyers rooms, for interpretation, sometimes varied interpretation. What is the status quo? The charges have already been filed in court. Just pending proper or formal arraignment before this particular order was made. Maybe I will advise INEC to share their sword and allow 18 to come when they can now properly approach the court and tell the court the dire truth of what the matter is all about, and then see what the court will say. I would rather ask that the order of the court, whether wrongly or rightly, be obeyed, pending the time that they will bring before the judge some of the facts concerning this case, why the order itself should be set aside. And so that's the way for us to go. We cannot in any way advocate that any judgment of the court, order of the court, should be disobeyed at any point, whether rightly given or wrongly given. We must obey. The only thing we can do is to probably go on appeal or have it set aside. That is the proper thing to advise.
Mr. Ubani, questions for you, Bukola Anayo.
Yeah, thank you, Mawkwe. Mr. Ubani, let me reiterate Mawkwe's question in the light of the issue that you raised the other time, and correct me if I'm wrong, that you said a court cannot stop a criminal trial. Is that what you said? Let me just confirm that.
Yeah, I don't think there's any competent court of the land that can stop the trial of an accused person if an investigation has been properly done by an agency that is actually allowed by law to do that, and that has been completed, and you want to arraign an individual formally, and they probably somebody rushed to court and they, oh no, I should not, because we come to a stage where armed robbers, armed robbery suspects and other criminals can take undue advantage of such a procedure and begin to stop their trial and say, look, I have filed a case against a so person, and for that reason, I'm not going to be charged. And before you know it, the matter goes up to Supreme Court, and they will forget even the main issue that should have actually been taken up by the court, and we are now pursuing the ancillary issue and all that. So I don't think it's a proper procedure for us to be entertaining, judicial intervention in matters that are purely within the responsibility of a security agency. Even this issue of stopping investigation, I have seen a situation. It has happened with a former governor, in Nigeria, where perpetual injunction was granted, restraining the investigation of an alleged crime. Recently, also, somebody who happens to be a former governor also rushed to court while he was being invited by the security agencies. So I am beginning to, and people are beginning to question the rationale of people rushing to court to stop, an agency from carrying out a responsibility that has been assigned by the law.
Okay, Dr. Ubani.
I advocate for rights, but we must also balance these things here.
Yeah, but if that is the position of the law, as you are putting it to us now, and you also say that there are two cases at play now. There's a criminal case, there's a civil case. Both of them originate from the same law. Both of them originate from the same process. How are they different?
if they are all both going to be using the same laws, the Electoral Act and the Constitution, for the prosecution and defense or whatever?
You know, how these things are sorted out, you know, is when all parties are joined, when all parties come before the court, and all the facts are made available. You find out that the court will always find a way to resolve these issues. What has happened now is that this order was made ex parte. Remember, ex parte means that that party was not put on notice. That order that was made yesterday was done ex parte. And so the court now has adjourned for the other party to come and show cause why the substantive relief, you know, will not be granted. So it means that they have opportunity now to present to the court, you know, their own side of the story. So the court will look at all the facts. The man who has, the woman who has gone to court saying, oh, don't try this person because it will affect the outcome of my election tribunal case. And the person who says, oh, I have a right under the law to charge somebody for a criminal act, you know, because it has nothing to do with the election petition matter that is going on. So the court now will now evaluate all the facts and then probably reach a conclusion. So there is a way these matters will be sorted out at the end of the day. They're applying the law quite all right. But the point is that the court always has a way of hearing every party in this, and then probably reaching a decision that we meet the meat of the matter.
Well, Dr. Ubani, following up on Ayo's concerns as well, recall that the candidate had withdrawn the suit, you know, sometime in April, saying that a lot of issues had come up, and this would seem a seeming U-turn, now filing another suit barring over the declaration of her emergence as winner as illegal. So will the establishment of culpability, which is what seems to be happening with the commencement of prosecution of the erring INEC of REC, will it also mean a guilty, you know, some form of guilt upon the candidate of the APC, which is why she has made a U-turn on this suit?
Well, the issue of election petition, as I said earlier, has nothing to do with guilt or innocence. It has to do with proving the fact that you have a grouse where you have gone to court to challenge the person whose election was, outcome has been declared by INEC, that he is the winner. So you are challenging whether the man is not eligible or that the election itself was marred by some malpractices or some level of corruption that made it, not tenable for the man to have been declared the winner, or that he did not garner the valid vote that should have actually entitled him to be declared the winner. These are the grounds that the woman has gone to court to challenge the man who is now the governor. It has nothing to do with this one that is going on, that, oh, this is what the police have actually found out from what transpired when he was presiding over the electoral process in Adamawa. One, was he the person that was supposed to preside over that process? I don't think so. Secondly, what was even the manner with which he presided over the process? Did he have to announce somebody when the election itself has not been completed? Was it not an electoral infraction that is criminal in nature, which is what the police now have done their own investigation, concluded, and then have passed over to INEC to now ensure that this, their worker, who has not done the right thing in the process, should be prosecuted. So it's a different ballgame entirely. It has nothing to do with the outcome of the election tribunal. It has nothing to do, because the ground upon which you challenge the winner is different. Now, this is criminal act that has been done by somebody who presided over that process. So I don't see the similarity. Only if you ask me, my own opinion is that the criminal case can still go on while the election tribunal case is going on. But whatever it is, the judge is capable. I'm very, very sure when all these facts are brought before him on 18th, he will look at the entire thing and probably, reach a decision that will settle everyone's heart. For now, people are really not.
Even though you have established that a civil proceeding shouldn't impact on a criminal proceeding, yet again we have seen this ruling by the High Court. Doesn't it place a huge moral burden, a moral question on the electoral process, and a wrong precedent, for future cases emanating from the electoral process?
What precedent are you saying now? What precedent has been established that you found that we should look at? What precedent? Can you be a bit clearer with that question, please?
Hello, Mr. Ubani.
Did you hear me? I said, what precedent are you referring to that has been established that you found?
Yes, exactly. This precedent where the court has stopped the prosecution, well, suspended the prosecution of the erring electoral officer.
Oh, okay. As I said earlier, you know, this order was made ex parte, remember? And the court has adjourned this matter to 18th of July, asking that the other parties should come to court and tell the court why the court should not in any way grant whatever the substantive relief is. So meaning that the other party will be given an opportunity to challenge that order that has been granted ex parte. It's an order granted ex parte. The other party was not put on notice. INEC was not put on notice. The Attorney General was not put on notice. Now that this order has been made, they will be able to file certain things before the court in order to tell the court, one, does the court even have jurisdiction at this point in time over this matter that is pending before the tribunal? Secondly, this is a criminal case, you know, that has been investigated by an agency that is authorized by the law, which has been completed and charges filed. Would any court want to stop the process of trying somebody who is alleged to have committed a crime under our law, under our jurisprudence? These are the issues that the court will establish on 18th. So I don't think that any precedent has been established yet until this matter probably gets to the Supreme Court. Then you can now say precedent has been established. But rushing to call people to protect their right, I believe in protecting rights. But the court also must be wary it not being used unduly in order to probably grant some right that does not exist. The right against trial does not exist.
But Dr. Ubani,
the right against prosecution does not exist. Right against being investigated by security agents does not exist.
Dr. Ubani, can you hear me?
Human law.
Yeah, now, if you say there is no we cannot call this a precedent yet, is there a precedent for this one in previous, cases or laws or whatever it is? Is there a precedent in law that such a thing has happened before, or that is being cited in any way, manner, shape, or form?
You're putting me in the witness box. Yeah, there's been one.
Okay.
There's been one where somebody was actually where EFCC was restrained from investigating him. I think it was done in perpetuity. I don't know what happened that EFCC did not appeal against that case. I don't know whether it is even late now for them, because it has taken several years for that appeal to come, and it remained like that. There was no trial. There was no investigation up to now. So that has been cited as a precedent. Recently, as I said earlier, one governor also rushed to court to stop the security agency from inviting him, but I think that eventually DSS had to invite him, and he went there and then has been released on bail. So I'm saying there has been precedent, but that precedent that I have is not with issue of trial. It is only issue of investigation. But we're now entering into the realm of trial, where you now say, oh, don't arraign this person until so thing is determined. I say it may be a dangerous precedent if we allow it to stand, because nothing stops an armed robber from also going to court and say, look, I should not be prosecuted because I have filed an action against the Attorney General over a matter that may not be related to the armed robbery incident. So I think it's not a precedent that should be allowed to stand. That's why I think will be a very defining moment, whether the court will allow such a precedent to stand, or whether it's going to set it aside. So we're all hoping to see, the reaction of the court concerning this particular precedent you have just mentioned.
Well, Mr. Ubani, the reason I raised the concern about precedent is that, during the general elections, ahead of the governorship elections, INEC had recommended, the sacking of some erring officials, and in fact barred them from taking part in the governorship elections of March. So if there was no candidates raising concerns over their own misconduct, and their own prosecution went ahead to smooth sail, it would seem unfair on their part where, that of an erring official which gained national prominence has been sort of suspended in this way.
Yes, that's why, as I said earlier, this should not be allowed to stand. Your concern is well noted. That, why was others, where were others prosecuted and nothing happened, and why is this one special? And some people have also raised the issue that, look, this hoodoo of a thing, that was so bold enough to do what he did. He had some people, that were actually behind it. But I don't want to believe that there are authorities that are backing him in what he's doing. He had gone to court to stop police investigation. That did not work. Now he's stopping his prosecution. I don't know how far he can go with this, but whatever it is, my joy in the land always is that our judiciary will always resolve this issue, no matter how naughty it is, no matter how complicated it is. At the end of the day, if they fail to resolve it at the lower court, you see that the Supreme Court at the end will clear the entire mess and make it look neater. And that is actually my hope in everything that. Yes.
Dr. Ubani, that's not to say that, you know, even the entire judiciary hasn't been questioned in terms of some of its decisions. You have also, yes. I mean, but one way or the other, saying that the decision that we're looking at now is something that, you know, shouldn't be allowed to stand. It also raises the issue, part of the issues that were raised when Chief Afe Babalola SAN became marked 60 years at the bar. Not 60 years old, but 60 years at the bar. I'm still basking in that fact. So those issues were raised. One of the issues that was raised was the fact of corruption, you know, having been so entrenched in the previous administration. There are those who will cite the responsibility of the judiciary in that, and that even the judiciary has become vulnerable one way or the other from the conversations, you know, at that event of yesterday. What is your take on the vulnerability of the judiciary, especially coming from the celebration of yesterday and the conversations that were had?
The judiciary will be as vulnerable as we want it to be. If we want a strong judiciary that is clearly independent, then you have to probably look at the state of your laws and then look at some of the things you have made available to the judiciary in order for them to function effectively and independently. It's very key. In SPIDEL, we have always, almost every year during our conferences, our attention has been, you know, geared towards the judiciary, because if we get it right at that level in this country, and I keep on saying it, and I've said it, you know, on your channel severally, that look, if we get a judicial system that is very strong, that is independent, that does not look at any person's pockets or look at any person's face or status or where you come from, then half of our problem, you know, or 40% of our problem in the country would have been sorted out. If any person knows that if he does anything wrong,
the question is
if
how.
He does anything wrong.
My apologies. The question then is how. It's something that you've talked about several times. So many lawyers such as yourself have talked about it, to the effect that I think it's Chief Yunusa who also said, who is a former NBA president, saying that some decisions of the courts, as far as he is concerned, shouldn't ever have happened. You have also said something similar this morning. So if we still have situations like this where, you know, strong pillars of judiciary in our country, such as yourself and a good number of people who are, some of them former presidents of the NBA, raising questions about the processes, the question then is, how do we get the kind of judiciary that we want, that, as you said, would be insulated from the vulnerabilities of the state?
No, my joy, if you remember, I'm going somewhere before the interruption, you know, at the end, because of the appellate option, because of the appellate, you know, court we have, most of the things we have at the lower court, you know, which we consider to be wrong, are usually corrected. Most times, you get up to the Supreme Court level, you see that these things are, you know, streamlined and, you know, well pronounced in such a manner that you will be happy. It's not as if to say that almost all decisions of the Supreme Court are not without any fault, you know, because they are us to human. But most of these wrongs we complain about are the lowest court. Most times are being corrected at the appellate, you know, court, you know, especially the Supreme Court, anytime there is an issue. But the point is that, the point I was trying to make is that we must, as a nation, you know, deliberately by policy, make sure that our judiciary is very, very strong. We must try as much as possible to respect the orders of the court. Whoever is in power, whether the president or the governor, whenever a court pronouncement is made, whether wrongly or rightly, we must obey it. The only thing you can do is to appeal.
Doesn't that in itself, Dr. Ubani, doesn't that in itself raise questions around what we often say, that the judiciary is the last hope of the common man? If
it remains the last hope, it remains the last hope. But I'm saying that why there are layers of, you know, judicial authority is when there is wrong at the lowest court. It can be corrected at the Court of Appeal. If it's not corrected at the Court of Appeal, it's certainly at the Supreme Court level. Okay. So those layers are inbuilt mechanism that is actually meant to correct these errors in case any, because they are still human beings.
Which also raises another question, Dr. Ubani. Yes. Justice delayed, they say, is justice denied, right? If that notion is still, that dictum is still very, very true, how then do we resolve the issues around electoral cases taking so much precedence that civil cases are left in the back burner, consequently delaying justice?
The conclusion we reached at the last conference of speed that I held in Lagos is that we must, as much as possible, try to enthrone fairness in our electoral process. Whatever we can do to determine the fairness of the process that the polling unit, we must do it as a nation, either using digitalization or using technology in order to enthrone fairness so that there will be less human interference in our electoral process. The moment we do that, the less burdensomeness, on our judicial system, because we are overburdening the judiciary. Almost every, look at the pre-election cases, most of them are still pending. And then the post-election cases now, they will not end until probably sometime in December or January. We are overburdening our judicial system. Why are we doing this? Because we have problem with the electoral process. The electoral process does not in any way ensure fairness. There is always problem at that level. At the polling unit, we don't have fairness at that level. Can't we do something that will really ensure fairness of the electoral process? At the polling unit, that is where leadership is decided, not at the court. We are overburdening the court. We are giving responsibility that the court shouldn't have. By determining the majority that should determine the leadership of any position. But now the judiciary is one doing it. So substituting the majority with that of minority. So what we can do is to make sure that we really, really ensure technology-driven electoral process that will reduce some of the infractions we complain about that make people to go to court.
Mr. Ubani.
Yes.
Particularly, one more from me now, particularly because of those, obvious weaknesses in the system, can we rule out the possibility that, this suspension of the prosecution of the erring electoral officer can be done in perpetuity if it's going to impact on, the case of the candidate of the All Progressives Congress? Can we rule that out?
Well, I won't want to probably, play the role of the judge now. The judge is going to determine this issue on 18th. Let him look at all the facts of the case, right from the respondent and that of the person who has actually gone to court and say, look, let's place this on balance, on balance of probability. Will this particular decision, or the trial process actually impinge on the election tribunal case that is going on? If the court finds, let him go ahead, but that will not be the end. Some person can go to Court of Appeal and up to Supreme Court concerning this. But whatever it is, we are of the opinion that there is no way you can stop criminal trial because of a pending civil case. I don't think that both of them are similar. It is a dangerous precedent if we allow it to stand. That's my own opinion.
Very, very interesting. You say there is no way it can stand, yet we have to obey the order of the court. Such a conundrum. Dr. Monday Ubani, former chairman of SPIDO, thank you so much for being a part of our program this morning.
Thank you for having me.
Yeah. We're back right after now. Do stay with us.